All right, ladies and gentlemen, good morning and welcome to the 28th Circuit Court for Wexford County. We're going to take up the case this morning of People of the State of Michigan versus Levi Kruger. This is file number 23-13698FH. Appearances, please.
Joanna Perry, Chief Assistant Prosecuting Attorney for the People.
Attorney Jeff Slocum on behalf of Mr. Kruger, joined by Zoom as is Mr. Kruger.
Mr. Kruger joins us today via Zoom from the Wexford County Jail. Mr. Kruger, are you able to see and hear the court, sir?
Yes.
All right, thank you. We are here today to conduct a plea. The court understands that pursuant to the court rules for 2.407, 408, and there's one in the section 6 too, and I think it's 6002, but don't hold me to it. That's going to allow us today to conduct the plea via Zoom. That's what this matter is set for. Ms. Carey, why don't you tell me what we're doing today?
Thank you, Your Honor. It's my understanding the defendant will plead guilty to added count 2, use of the controlled substance, cocaine, and in return the people will dismiss count 1, possession.
All right. Mr. Slocum, is that a complete and accurate statement of the pretrial agreement?
Yes, that is my understanding. A little bit of additional is that it is a 1-year misdemeanor.
All right, I got that. All right, Mr. Kruger, have you heard what the attorneys have told me that we're doing today?
Yes, I have.
Is that how you wish to resolve it?
Yes, I do.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
You may lower your hand. Mr. Kruger, before we begin, turning your attention back to April 20th, 2023, were you on probation or parole at that time?
Yes.
And has there been a probation violation held so far somewhere else, Mr. Slocum?
No, as I understand, there is not.
Okay, Mr. Kruger, were you violated on probation anywhere?
You mean other than Wexford County?
All right, I think I see possibly where there's a misunderstanding. All right, so here we go. Have you ever been previously convicted of a crime and placed on probation?
Oh, no, I have not.
All right, so therefore the answer should have been no, you weren't on probation or parole. Next question. Were you on bond pending felony charges anywhere on that date?
No.
All right, thank you. Now you are currently charged in a felony information, which is just a charging document with a single count. That count is possession of the controlled substance, cocaine, less than 25 grams. That is a felony punishable by up to 4 years and or up to $25,000. I'm told today that you are going to enter a plea of guilty to an added count 2 of a lesser charge of use of the controlled substance, cocaine, which is a misdemeanor punishable by up to 1 year and or up to $1,000. Is that what you understand to be your pretrial agreement today, sir?
I believe so.
In exchange for that, of course, I'm sorry, I forgot to complete the sentence. The other portion of that agreement is that the original count will be dismissed.
Yeah, yep.
Oh, hold on. All right, hold on. Miss Carey's got something else to throw at us. What you got?
On March 22nd of 2023, he was convicted, it looks like sentenced on operating while intoxicated
Oh,
in district court,
so,
and he got probation.
okay.
I
Well,
think he was on probation.
so we're gonna go back, Mr. Kruger. We're still dealing with the confusion as to the answer of my question of, were you on probation at the time that this offense allegedly occurred, which was April 20th of 2023. Miss Carey, it's okay. Miss Carey tells me that you had been previously convicted of some kind of operating while intoxicated or impaired charge in the district court, and that you received probation. So, were you on probation at the time this offense occurred?
Yes, I was.
And did you receive any violation or probation violation as a result in that other case?
Well, when I was brought in, it was on a violation, so I don't know if that necessarily affected that.
Okay. Well,
I
let's
think-
cut to the chase and explain why I asked the question. If you plead guilty today and the court finds you guilty of the added count 2, as we discussed a moment ago, that could be used against you in that other case as a grounds for a probation violation. And if that has already been done, then it doesn't matter. If it hasn't been done, you need to be aware that you could be violated on your probation in that other case. So if you were on probation for a drinking and driving related offense on the date that this offense occurred back in April 20th of 2023, it could be used against you. Now, it would most likely have already been done, but I don't know if there was a probation violation. Do you know, Mr. Kruger, if you were violated on probation and received some additional time or sentence?
So yes, I was violated on probation at the time.
Okay.
And yeah, so it shouldn't affect anything. That probation's been terminated for quite some time.
All right, good enough. Then that was the reason why I asked the question, and you've answered it clearly. So now we're
Okay.
going to pick back up where we were. And that was when where I was just getting ready to talk about your rights. Now, if you enter this plea of guilty to the added count 2, you will not have a trial of any kind. By pleading guilty, you'll be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose and the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond, excuse me, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify yourself at that trial if you chose to testify. Mr. Kruger, do you understand those 10 rights?
Yes, I do.
Are you willing to waive those rights today, sir?
Yes.
Additionally, any appeal from the conviction and sentence pursuant to this plea will be by filing an application for leave to appeal to the Court of Appeals and not a claim of appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. If this plea is accepted, you will also be given up the claim that the plea was a result of any promises, threats, or inducements not disclosed to the court today on the record, or that the plea was not of your own free choice. Mr. Kruger, other than the terms of the pretrial agreement, which we talked about already, have there been any other promises, threats, or inducements to force or compel you to plead guilty that I have not heard about?
No, there hasn't.
Are you entering this plea of your own free choice?
Yes, I am.
Now, Mr. Slocum is probably trying to give you an idea or estimate based upon his experience as to what the court may sentence you to. My question for you is, has he or anyone told you, promised you, or asserted to you exactly what the sentence would be?
No,
Knowing all that, do you still wish to enter the plea of guilty to the added count 2 that we talked about?
yes,
The added count 2, use of cocaine, and misdemeanor punishable by up to 1 year and or $1,000. How do you plead?
guilty.
Before the court can accept your guilty plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention back to April 20th, 2023 in Greenwood Township here in Wexford County. What happened? Were you stopped by a law enforcement officer?
Yes, I was.
Looks like it was a deputy from the Wexford County Sheriff's Department. Is that right?
Yes.
And was this a traffic stop?
No.
Tell me
it
about it.
was, well, I just, I basically was parked and somebody must have, reported the car or something and he came and picked me up.
Okay. Did you either use or possess some cocaine on your person at that time?
It wasn't the substance, but, I had something.
What was the substance that you had on you?
Well, I didn't have any substance on me. I just had a piece of paraphernalia apparently.
There was a pipe here on it with residue
All right.
of cocaine. It tested.
Was there, so you said a paraphernalia. Did,
Yeah,
or was that paraphernalia a smoking pipe?
yes,
And did it have the residue in it for that substance, cocaine?
it must have, yes.
And what had you recently used it for the ingestion or smoking of cocaine?
No,
All right, let's just not do this today. I'm not going to take the plea. We're setting it for trial. We'll see you on Tuesday. I will,
Your Honor,
or
could I go into, could I go into a
Nope.
breaking room?
you should have done this ahead of time. I'm not going to come here to a plea and schedule a case for a plea and be jerked around by, he doesn't know, all he knew is he had something called a smoking pipe. He didn't use it. He didn't knowingly possess it. I'm not doing this. You as a defense attorney should have done this with your client ahead of time. We are going to move now to a trial date. So let's take a look here. We have a trial date scheduled for, I think, on Tuesday, but I know the prosecutor has been preparing for another trial. Madam Clerk, can you tell me what the next trial date is? Do we have anything the following Tuesday?
It would be 2 weeks, Judge.
All right. Well, we're just going to tentatively set it for 2 weeks, but of course, I understand that the prosecutor has to arrange a key witness, which what I anticipate to be a lab tech. And I know the lab techs are quite busy for the forensics crime lab. Therefore, I will not set it for a trial date today. We'll go ahead and have this figured out.
Thank you.
All right. Thank you all very much. We are adjourned. We're ready. All right, we are back on the record now. This time we're taking up the case of People, the State of Michigan versus Derek Lane Wise. This is file number 24-13749-FH. Appearances from counsel.
Good morning, Your Honor. Corey Wiggins on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Wise. I would apologize to Mr. Wise because I had originally told him that I would not be here. And in fact, I am. That's why I was trying to get his attention.
All right, congratulations, Mr. Wise. Your attorney was here today. Mr. Wise, are you able to see and hear the court, sir?
yes, sir.
All right, thank you all very much. Now, we're here today for a pre-trial conference, and that was conducted briefly in chambers between myself and counsel. And I was informed that there would be a entrance of a plea today pursuant to a pre-trial agreement. Mr. Wiggins, why don't you go ahead and state for us what that agreement is?
Your Honor, it's my understanding the defendant will plead guilty to count number one, possession of methamphetamine. The people dismiss the second subsequent defense notice along with the official third notice.
Mr. Harrison, is that a complete and accurate statement of the pretrial agreement?
It directly comports with my understanding thereof, yes.
Mr. Wise, have you heard what the attorneys have told me what the pretrial agreement is?
Yes,
Is that how you wish to resolve this case today, sir?
yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Mr. Wise, turning your attention back to September 6th, 2023. Were you on probation or parole at that time?
Yes, I was.
Mr. Harrison, was there a probation or parole violation?
There is one contemplated in Grand Traverse County.
Okay,
There's been some informal discussion about the arrangements that will be made pursuant to that matter, so we are comfortable in proceeding.
is there a hold on him from
Indeed.
Grand Traverse? Okay. Now, Mr. Wise, that was important or is important because if you make an admission to a crime here and are found guilty, that could be used against you in the other county, which I'm told is Grand Traverse County, as the grounds for a probation violation. You understand?
Yes,
Do you will still wish to proceed today, sir?
yeah,
All right. Now, you are currently charged with the single count of possession of the controlled substance methamphetamine. Now, that itself is a felony punishable by up to 10 years and or up to $15,000. Now, there are two potential sentencing enhancements, and the prosecutor would, if it proceeded to trial, have to choose which one it wants to proceed on. A second or subsequent drug enhancement is there, and that could increase the maximum punishment from 10 to 20 years and from $15,000 to $30,000. There is also a third habitual felony offender enhancement, which could also do the same thing, meaning increase that punishment from 10 to 20 years and from $15,000 to $30,000. But I'm told today that if you plead guilty to count one, the sentencing enhancements will both be dismissed. Is that what you understood to be the terms of your pretrial agreement today, sir?
yes,
Now, by entering a plea of guilty, you'll not have a trial of any kind. You would be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose and the prosecutor and court consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify yourself if you chose to testify. Do you understand those rights, sir?
yes,
And are you waiving those rights today, sir?
I am.
Additionally, any appeal from the conviction and sentence pursuant to this plea will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Additionally, if this plea is accepted, you will be given up the claim that the plea was a result of any promises, threats, or inducements not disclosed to the court today on the record, or the plea was not of your own free choice. Mr. Wise, other than the terms of the pretrial agreement that I talked about already, have there been any other promises, threats, or inducements to force or compel you to plead guilty that I have not heard about?
No,
Are you entering this plea today of your own free choice?
yes,
Now, Mr. Harrison has probably talked to you about the Michigan sentencing guidelines, try to give you an idea or estimate as to what he thinks the court may sentence you. My question for you is, has he or anyone promised you or told you exactly what the sentence would be from this court?
No.
Knowing all that, do you still wish to enter the plea of guilty as we discussed already?
Yes.
As to count one, possession of the controlled substance, methamphetamine, how do you plead?
Guilty.
Before the court can accept that plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to September 6th, 2023 in Cedar Creek Township here in Wexford County. What happened? Let me ask this question. Were you stopped by law enforcement or did law enforcement find you someplace? Tell me about that.
Yes, I was pulled over, pulling into the house where I was staying.
Okay, and did that law enforcement officer find some methamphetamine either on your person or in that vehicle?
Yeah, I told him it was in my door.
All right, and so obviously you knew that it was there at the time?
Yes.
And did you know that it was methamphetamine?
Yes.
And approximately how much of the methamphetamine was there, sir, if you know?
It was less than a gram.
All right, and did you have any lawful reason to possess that substance?
No.
Thank you. Mr. Wiggins, do you believe the defendant has provided a factual basis to support count one?
I do, Your Honor.
Mr. Harrison?
Yeah, I'm rather impressed by it, yes.
Mr. Wiggins, are you aware of any other promises, threats, or inducements that I haven't heard about?
I'm not, Your Honor.
Mr. Harrison?
Nor am I.
And Mr. Wiggins, do you believe that the court is in compliance with Michigan Court Rule 6.302?
I am.
Mr. Harrison?
I concur.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided today under oath on the record by the defendant satisfies the elements for count one. Therefore, the defendant is found guilty of count one. The sentencing enhancements discussed earlier will now be dismissed at the time of sentencing. Mr. Wise, this case will now be set for sentencing. I can estimate that it will be in about 4 weeks from this coming Monday. We do sentencings in criminal cases every Monday morning. Between now and then, a pre-sentence investigation report must be prepared by an agent of the Michigan Department of Corrections. That will require 2 steps for you to be involved. 1, you will receive a packet at the jail. You will complete that packet and turn it back in to the Department of Corrections. 2, you'll be subject to an interview with an agent from the Department of Corrections, and you have the right to have your attorney present at the time of that interview. This report will include a description of the offense, description of the pretrial agreement, any statements or information you make or provide in the preparation of the report, as well as a score in the Michigan sentencing guidelines and a recommendation as a sentence. Please note that it is merely a recommendation, as it is the court alone that determines the sentence. Each party will receive a copy of this report prior to us coming back to court, and I trust that Mr. Harrison or someone from their office will come and go over it with you. Each side has the right to come before this court prior to the sentence and make objections or request corrections or amendments to that report, as we must make sure that that report is complete and accurate before the court issues a sentence. Do you understand, Mr. Wise?
Yes, sir.
Mr. Wise, do you have any questions about anything that we have done thus far today?
No.
All right. Anything else on behalf of the people? Mr. Wiggins?
No, Your Honor.
Yeah, Mr. Harrison?
Nothing further. Thank you, Your Honor.
Thank you very much. Mr. Wise, if you have any other questions, please make sure you reach out to Mr. Harrison or his office. Have you been able to see and hear us clearly enough today, sir?
Yes.
All right. Thank you very much for your time. We are adjourned.
Thank you, Your Honor.
Thank you.